Law Vlog Thursday, and we're going to be talking about Articles 11 and 13 of the European Union Copyright Directive, the EUCD, and Brett Kavanaugh, but don't worry, it's not going to be political. That's the hook. Alright, so unless you live under a rock, you've heard about this thing called the EUCD, the European Union Copyright Directive, which is some form of guidance governance that is intended to update copyright laws for the internet age. I'm going to retroactively put that in scare quotes. It's intended to update the copyright law for the internet age, because apparently the existing laws are inadequate to deal with the internet, according to some. Regardless, the EUCD is, it's a complicated thing, so much so that I've been researching it for the last few days and can't find any articles that don't just regurgitate the same sort of catchphrases from every other article. Article 11 is the link tax. Article 13 is the upload filter. They're going to destroy the internet according to some. They are intended to protect creators according to others. This is my understanding of what Article 11 and Article 13 are. Article 11 is called the link tax, which is basically a license or a fee that you have to pay in order to use a news source so that that third party who generated or created the news source doesn't have their material ripped off without them getting any revenue or compensation or traffic or whatever. The idea being that news aggregators like Google, who would otherwise deprive, I presume, the news creators or the article creators or the copyright holders of revenue or traffic, would have to pay a license or a fee if they use that news article in their news aggregators. The way it's being described is that Google will cover the news but provide a link to the source. Now, people are going to read the article but not actually go link to the source, so the copyright holder or the person, the author of the news article, is not actually going to get any benefit from Google providing the news and a link which no one's going to click. So if they do that, they have to pay a license or a fee in order to use that news source, as would any other smaller platform have to do the same thing. The fear, according to many, is that while Google will be able to afford the tax or the license fee, smaller websites will not be able to do it, and that it'll sort of kill any form of free speech or smaller news aggregators on the internet from diffusing news. Some suspect that that might be the intention of it to begin with, but we'll get there. Article 13 is called the upload filter, and it basically would hold any platform, personally in the corporate person sense, but it would hold them liable for any copyright infringement by their users, subscribers, members, uploaders. So for clearest example, YouTube, if someone were to upload a bootleg version of Star Wars, I don't even know why they'd want to do that. If someone were to upload a bootleg version of Star Wars onto YouTube, if YouTube didn't take it down, not only could the copyright holder go after the uploader, but they could hold YouTube liable directly for the copyright infringement. And again, the people supporting this claim that it is to protect creators and protect copyright holders and to protect the legitimate interests of people who create. The critics say it's going to kill free speech, it's going to kill fair use, it's going to kill parody, because the filters, which are going to have to be automated and not human, are not going to be able to distinguish between fair use and copyright infringement, and all sorts of stuff is going to get struck from the internet, etc., etc., etc. Here's the thing. As far as I understand, the rationale behind Article 11 is a legitimate one. Quoting substantial portions from news articles and then providing a link is basically the same thing as stealing someone's video but then providing a link to their video in the description. You do deprive the creator of the traffic, revenue, exposure, recognition that comes along with them having created the work. Quoting 90% of the article, or even just a substantial portion of the article and providing a link, does nothing to help promote, compensate the creator. The question is, what in the existing copyright laws is unable to deal with that problem? My answer is nothing. Existing copyright laws provide for the exception of fair use, which is use as little as possible for commentary, newsworthy purposes, parody purposes. If you cross the threshold for what is the minimum amount required in order for you to get your point across, then it's no longer fair use, then it's copyright infringement. We've also touched on this in previous episodes of Law Vlog Thursdays. The fair use defense is an affirmative defense that is raised once the alleged infringer has been accused. It doesn't exist as a justification to use it, it exists as a defense to an accusation of having copyright infringed. So I don't understand what is currently deficient in existing copyright laws that is unable to address what is being addressed now purportedly by the Article 11 link tax. And Article 13, it already exists! Just ask PewDiePie, who had a video claimed for copyright infringement because a thumbnail and a portion of the video used an image of Gru from Despicable Me, and it was claimed on that basis of copyright. YouTube already has the automated algorithms, or whatever, call them spider bots, in place to track, flag, and claim copyrighted material. Try uploading a pop song and see what happens. You'll either get a copyright notice strike, you'll either have it claimed within a few minutes, or you'll get a takedown notice. The system is already there. and it is already ensuring that there's no copyright infringement. You want to know the reason why Facebook, YouTube, and Google are opposing Article 13 now? Only because it holds them personally liable for failure to do it. As it is now, they're still doing it. They're still claiming copyright on content from creators. In my opinion, they are unfairly claiming copyright on stuff that does qualify for fair use. The only reason they oppose this Article 13 is now because it would hold them personally responsible, financially responsible, in the event that one of the videos got through their algorithm or their bots. Google, YouTube, Facebook, they're not opposing this to protect the interests of creators. They are strictly doing it to protect themselves. As it currently stands, they are enforcing a de facto Article 13 on a daily basis. They just don't want to be held personally, financially, economically responsible in the event that they don't do it to 100%. Oh yeah, and another thing which people don't necessarily fully appreciate, this EUCD, it's a directive of the European Union. Even now that it has been passed, because the EUCD has been passed in its modified versions of Article 11 and 13. Hold on, most important thing, like, share, and subscribe. Hit the notification bell, booyah. It's not a law. It has been passed by the European Union, which now gets to vote on approving it, I think in 2019, formally. Even once it's formally approved, it only becomes basically like, I think the analogy would be like a treaty that then the nation states have to enact by way of national law. Because the EUCD, even once and if it's approved by the European Union, does not become automatic law for the member states. Each member state, I believe, has a 2-year period within which to reflect the EUCD in their national laws. Now, someone in the comment section can please help me with this, because I haven't been able to find out what exactly is the sanction if a nation state fails to comply within the 2-year period with the EUCD. Apparently, the European Union can impose sanctions for any member state that does not enact it into national law within the 2-year period of it having been passed by the European Union, but I have no idea what those sanctions can possibly look like. If anybody knows, comment down below and I'll pin it to the top, because it's an interesting question. The other thing is people complaining about the fact that the law is too ambiguous in its wording. It doesn't define what a snippet is. It doesn't define what is going to fall within the ambit of a link tax. It just spit, sorry. It doesn't define it. People are saying it's so vague and ambiguous that the giants, Google, YouTube, are going to comply with the strictest versions of it so as to ensure that they don't get in trouble, which is going to kill internet creativity, content creation. Others say that Google, YouTube are going to use it for political purposes to go after, with utmost vigor, political ideologies and political platforms that they don't agree with, while being lax on the ones they do agree with. We'll see. All that I know is that vaguely drafted laws have rarely been held to be enforceable. So there's a part of me that says the vaguer the better, because it will get in front of a judge and a judge is going to say, "This is so vague and it's unenforceable." Bring it back to the legislators and have them define the law in a clear and concise way that allows me as a judge to adjudicate on its interpretation. That does it for the EUCD. Brett Kavanaugh. Again, for anyone living under a rock, you haven't seen what's been going on. A brief summary. Brett Kavanaugh has been nominated to the Supreme Court. They have these confirmation hearings where people ask him questions on his judgments, on his judgment, on his past, on his thoughts on various political issues, which are going to be at the center necessarily of judgments that he's going to be called to render on in the future. There were 4 some odd days of hearing. On the last day of the hearing, Dianne Feinstein, Senator of California, dropped an anonymous letter from someone who was accusing Brett Kavanaugh of sexual improprieties dating 36 years, I believe, when he was 17 and she was 15 in high school. At first, the accusation was anonymous. The letter was not disclosed. The names were withheld, and Dianne Feinstein submitted it to the FBI for investigation. The accuser has since come forward, and whether or not she's actually going to testify before Congress on Monday, to be determined. It's going to be Thursday by the time you watch this, before the Monday, so time will tell. The accusations date back 35 plus years. The accused, Brett Kavanaugh, was 17, and apparently he locked her in a room, tried to remove her clothes, apparently put his hand over her mouth. She was scared, and as anyone would be under such circumstances. I'm not expressing any opinion on the credibility of either of the parties. It just brings up a very interesting question in law, something that most people don't actually think about: statute of limitations. For those of you who don't know what the statute of limitations are, it's the period within which a crime can be prosecuted. It's the period of time within which a complaint can be brought, failing which it is what we call extinguished in certain jurisdictions, prescribed in other jurisdictions. Basically, there is a legislative time frame within which certain civil criminal complaints have to be brought, failing which they can no longer ever be brought. There are a few crimes which have no statute of limitations. Murder, crimes against humanity, there was another one. Espionage. I think treason or espionage has no statute of limitations, meaning if you ever do it, you will never sleep soundly thinking that you can never be prosecuted for it. Oh yeah, the other ones. Kidnapping, fraud and embezzlement for some reason in certain jurisdictions. Oh yes, and one very humorous one, not paying back your federal student loan, because the government is never going to be deprived of a recourse against someone who has taken money from them. But the statute of limitations, it applies criminally and it applies civilly. So, for example, in Quebec, which is where I'm a lawyer, we call it prescription. The period of prescription after which your action is prescribed. It's extinguished. You can no longer take it. Civilly speaking, for most infractions, it's 3 years from the date the cause of action arose. Your partner defrauds you out of money in a company that you own together, and you find out about it, but you don't do anything, and 5 years later you send a letter of demand saying, in 2013 you stole money from me. Guess what? The action is prescribed. You're going to get a letter back from opposing counsel saying, that's nice, and you had until 2016 to take this action. You didn't. It's prescribed. You no longer have any right to come after my client. These things vary by jurisdiction. For crimes, it is also extremely jurisdictionally dependent, depending on the crime, depending on the country, depending on the state. Okay, so it's 11:10 at night, and in editing this video together, I realized that I forgot to say something relatively important. I did mention that all of this is jurisdictional, so that the statute of limitations per crime will vary depending on jurisdiction, and I forgot to say that in Canada, there is no statute of limitations on serious crimes. So in Canada, under the criminal code, you have what are called summary offenses, which are not serious criminal offenses, and then you have indictable offenses, which are serious criminal offenses. Murder, rape, kidnapping, theft over $5,000. In Canada, there is no statute of limitations on indictable offenses. There is a statute of limitations on summary offenses. So that is a very, very big distinction between Canadian criminal law and US criminal law. Not to get too much into the details, it is a distinction I forgot to mention earlier, and it's one that's sufficiently important that I have to add it now. Back to the rest of the video. But the question is now, why does prescription exist in the first place? Why is there a statute of limitations in the first place? Why can't you just have forever to take any claim against anybody? Why? You know, if you're answering to your computer, I can't actually hear you, but good answer. Generally speaking, there are 3 principles for which statute of limitations exist in the first place, but they all are basically interconnected by one overarching theme. One reason why statute of limitations exists is that if a plaintiff has a claim, they have to pursue it with reasonable diligence. That means taking an action within a reasonable period of time. What is reasonable? Jurisdictionally determined. The follow-up reason is that if the plaintiff does not pursue the claim with reasonable diligence within a reasonable period of time, there is a reasonable concern that the defendant might lose evidence that would be necessary to prove his or her innocence. The third reason, reviving a long dormant claim may result in a greater injustice than justice. Now, these 3 principles basically, they have one overriding theme, which is natural justice. There are 2 parties in the accuser-accused context. They both have rights. The accuser definitely has rights, but the accused also has rights. The accused has the right to know that he or she can intelligibly, reasonably defend against an accusation. The longer that goes by between the alleged act and the accusation, the more likely it is that the accused will have lost, disposed of, or lose track of key pieces of evidence that could exonerate him or her. And there's a big caveat to taking an action within a period of time in prescription. There is what we call, at least in Quebec, the impossibilité d'agir, which is a defense against having not taken a claim within the period of limitations. That is the impossibility to have acted. The most obvious example which they use in law school is you're in a coma and you wake up from a coma 4 years later. It's not exactly the case that you're going to be prescribed from having taken an action that occurred 3 years ago because you were in a coma. You were literally incapacitated, impossible for you to have taken the action. If you were a minor when you were a victim of the criminal act, the statute of limitations to take the action will be extended. Jurisdictionally, it'll go from a few years after which you become a major, but it is all determined by jurisdiction. All that to say, there are exceptions for which an action is not brought within the limitations period. But what these situations highlight is the importance of that overriding principle of natural justice to both protect the accuser and the accused. You know, and now some of you are going to say, well, going back to the Brett Kavanaugh situation, we're not talking criminal. No one's suing him criminally or civilly. And in that sense, it's almost even worse, where it's no longer an issue of actually having the opportunity to be convicted or exonerated in court, civilly or criminally. That's no longer at issue, and that's no longer even a right of the defendant. Right now, it is purely the trial by public opinion for claims that are made well beyond any statute of limitations, well beyond any period for which there can actually be a guilty or innocent verdict in court. Now it's no longer a court that's going to adjudicate, it's just going to be the court of public opinion. And so it's all a very tricky situation, but these real-life situations actually highlight real-life lessons as to why these statute of limitations even exist in the first place. By the way, this says hashtag I am a pitbull. In French, je suis un pitbull. This is a shirt from Little Bear, the pet supply store up the street. The French, sometimes people think it looks like Jésus and pitbull, but it's je suis un pitbull en français. See you next week. Peace out.